First of all, let me thank you all for coming. So, I will keep this as short as possible. I trust each of you with the brand I built, and lately, I'm not sure if that trust was misplaced. Azlan, you left in July. By September, BioCare was open, 10 kilometers from Taman Sri Bayu. Our agreement was clear. No cooperative clinic within 30 kilometers for 5 years. And yet, here we are.
The agreement ended, Arif. It was mutual. I have moved on professionally.
Moving on is one thing. Using my branding, my stuff, and the platform we built with POS, that's not moving on. That is what we call as copying and pasting. And not to mention, you've also used POS Diagnostic as your screening health tools.
I don't see the problem. What's wrong with using the same screening tool from the same company?
Because Sarah, I don't have a signed contract with you. That was my mistake. But you must not forget that you give me your word, like no involvement in similar programs for a year. A few months later, you are consulting with our competitor.
Dr. Arif, I didn't sign anything. It was an email. I thought it was informal.
And Ameh, you are still with us. But a proposal with our design, our passion journey visuals circulating among investors, what should I do?
It was a draft. Just an idea. I haven't left. I also haven't opened anything yet.
Not yet, you say, but the intent is there, right? I can feel it. If you are preparing to leave, have the decency and courage to say it, and not just hiding behind the proposal. This is not just a common business we all involve. It's a name, what we call as a trust. If any of you still have a shred of loyalty left, then at least try to protect it. If not, don't expect silence from me moving forward. Thank you for meeting me on short notice. As you heard, I wish to take action against them since they blatantly breached the agreed contracts. But I want to hear your legal advice on this matter.
I understand, Mr. Arif. We'll discuss the affirmation issues one by one. Akansah and I will walk you through each matter and give our legal opinion and recommendations.
Yes, let's start with the first issue, which is the validity of the clause itself. According to Section 28, Contract Act 1950, clauses which contain ROT are considered void. This is according to the statement, every agreement by which anyone is restrained from exercising a lawful position, trade, or business, any kind of, is that to extend void. However, there are several exceptions which legally allow this clause, and they are to uphold fairness. These exceptions are sale of goodwill, partnership agreement, and also employment contract if the restriction is reasonable. Malaysian court narrowly interpret ROT clause, but may enforce them when a party agrees with another party to refrain from carrying a similar business within specified range or period, and local time limits as long as the specified limits are reasonable according to the nature of the business, and necessary to defend alleged business's benefits such as goodwill and proprietary tools.
Okay, you can see the examples of ROT in cases like Polygram Report Sdn Bhd versus Hilary Ang and Ors. That the fact of the case is about the Polygram Records, which is the plaintiff, signed a recording agreement with Hilary Ang and other members of the brand search, which included a restraint of trade clause preventing them from performing or recording for other companies during the terms of the agreement. Despite the clause, the defendants, the band members, signed a deal with another recording label and recorded an album. Polygram sued alleging breach of the restraint clause. The MPGS partnership follow Partnership Act 1961, a statute which governs the formation and dissolution of partnership and of the main. So, we'll take a look at the ROT clause in the MPGS agreement. Here, the two major restrictions are: the first one is doctors were not allowed to promote, market, or plan any clinic that would compete with Arif Medical within 30 kilometers during the partnership. Second one is after leaving, they are not allowed to open, manage, or advise any general outpatient clinic within 30 kilometers of Arif Plus clinic for 5 years. Applying the affirmation case, which is Polygram Records versus Hilary Ang and Ors, we can assume that ROT clauses in MPGS agreement are necessary to protect the interests of Arif Medical and reasonable. They are legal and thus need to be carried out by the agreed parties.
Now, we'll discuss what action we can take against Dr. Azlan. Mr. Arif not only he has established another clinic within the specified radius in contract, which is 30 kilometers radius, he also copied Arif Medical's promotional materials and brand. Am I correct?
Yes, it has caused damage to Arif Medical. Some customers confuse Biocare as one of our establishments, and some have also gone to it instead, causing Arif Medical to slowly lose customers over time. What's worse is that some of my customers receive automated appointment reminders from BioClinic. If this goes on, my business might suffer a huge blow.
I understand, Mr. Arif. Hello?
Thank you very much, Mr. Arif, and please accept our sincerest apologies for any inconvenience caused. We truly regret that. Due to time constraints, we have to proceed with this consultation online instead of meeting in person. Now, let's continue from where we left off previously.
I understand. Although he'd left the partnership, the ROT clause should still apply to Dr. Azlan. Now, under Section 28 of the Contract Act 1950, such restraints are generally wide, but they can be upheld if they fall under recognized exceptions and are reasonable in protecting legitimate business interests. Let's take a look into this one case, for example, Polygram Records Sdn Bhd vs Hillary X. As Ms. Nusra mentioned earlier, about the facts of the case, the issue arises is whether the restraint of the trade clause in the recording agreement was valid and enforceable, or the void under Section 28 of the Contract Act 1950. The court held that the restraint of the trade clause was valid as the clause was reasonable in scope and duration. It was necessary to protect the Polygram legitimate business interests, especially its investment. I must press that the ROT clause must fall under the ambit of Section 28 because, you see, Arif, it's a very strict clause and most of the cases that exist today generally prove the clause to be void. For example, in the case of Nagadevan Analaki Mahalingam versus Millennium Medicare Service, where the clause was found to be void because it fell outside of the exception state.
Alright, Mr. Arif, your clause is similarly reasonable and falls under the exception 2 and 3, which are limited to 2 years and a 30 kilometer radius and designed to protect your proprietary systems, patient base, and internal processes. Furthermore, the fact that Dr. Azlan had insider access to trade secrets and patients' information and is now using that knowledge to directly compete adds weight to your claim. This is not just a breach of contract, but potentially misappropriation of confidential assets. Therefore, our recommendations are: first, you can file a claim in the High Court for breach of restraint clause. Second, you can apply for a permanent injunction to stop Biocare from operating within the restricted area. Third, you can claim compensatory damages for financial loss and exemplary damages if bad faith is proven. And the last one, you can apply for an interlocutory injunction immediately to prevent further harm before the full hearing.
So, what evidence would we need?
Decline migration patterns, financial statements showing decline, and evidence of confidential information usage. Internal documents or emails showing intention or planning could also be crucial. Given the precedent set in Polygram and the clarity of your clause, your case has the strong chance of success in court.
Let's discuss the third issue regarding Pulse Diagnostic and their failure to register their health screening platform, which you say was also commercially used despite grant restrictions.
Yes, that's right. I'm worried that this breach our contract and whether I can terminate it and claim damages.
Alright, let's break it down using a legal framework. First, we identify the issue. The issue is whether Pulse failure to register the software and their commercial use of grant-funded platform breaches your contract and allows you to terminate the agreement. So, the core issue is whether Pulse diagnostic actions constitute a breach that renders the contract void or unenforceable.
Under Section 24 of the Contract Act 1950, any contract based on an illegal act or act against public policy is void. In addition, the National Digital Health Programme 2020 expressly prohibits commercial use of grant-funded platforms for 5 years. The Ministry of Health regulations require proper registration before any public use to ensure safety and compliance. A relevant case here is Yogananki versus Chan Chi Koo 2013 MLJU 770. In that case, the court examined an agreement which appeared lawful, but upon closer inspection, it was made with the restraint to circumvent transparency and corporate duties. The court ruled that Even though the contract had all the formal elements, it was void because its real objective was against public policy.
Applying this to your case, Pulse Diagnostic failed to register their platform as required by MOH before launching it to the public. They also breached the grant terms by using the platform commercially within the prohibited period, just like in Yoganandini, where the contract was void because the agreement facilitated illegal activity. Here Pulse actions violate regulatory and grant condition, making the contract unlawful.
What does it mean?
This means the contract you have with Pulse is legally void or at least voidable because its subject matter involves illegality and contravenes public policy. Therefore, you have legal grounds to terminate the contract and pursue damages for losses caused by Pulse breach and unauthorized commercial use.
In conclusion, Dr. Arif, you are entitled to terminate the contract due to Pulse regulatory violation and the illegality under the contract. You can also seek damages for financial losses resulting from a breach.
Thank you. I understand the situation clearly now and the legal basis of our position. Now let's move on to the issues me with Pulse Diagnostics. First, BioCare Clinic has been in direct agreement with Pulse Diagnostics, even though it was obviously stated in the National Fund grant that commercial use is not allowed for 5 years.
Okay, the main issue here is whether you can sue BioCare for making a direct agreement with Pulse, thus using a digital screening while partially funded by a public grant under the National Digital Health Program 2020, with the condition that it was not to be used for exclusive or commercial profit for 5 years. Let's talk about the legal implications. Section 18, which relates to misrepresentation, might be key here. Did Pulse ever assure you that your partnership would remain exclusive?
Yes, because the agreement was entered by the operations team.
And we also need to look at Section 24, which invalidates agreement if the object or consideration is unlawful. Lastly, there is Section 40, which allows for rescission of contract in the event of a breach.
Is there any reference from any cases related to the section you have mentioned?
Yes, you can see from my example research case, namely Your Tempo and Anur vs Bench, Win Sendirian Berhad, and Anur and other suits for the Section 18, Merong Mahawangsa Sendirian Berhad and Anur vs Dato Shazrel SK bin Abdullah in terms of Section 24, and lastly Section 40 in the case of Tan Kok Siang vs Kemuning Setia Sendirian Berhad. My partner will give you a further explanation regarding this matter.
Firstly, let's take a look at the case of Yoh Tiampo and Amar versus Bench Win Sendirian Berhad with N. Amar. Held that misrepresentation in agreement, making it voidable option for the party whose consent was so caused. The first defendant could resign the contract on this ground, but it was not the one that has been relied. In the case of Merong Mahawangsa Sendirian Berhad and Amar versus Dato Shazrel SK bin Abdullah, stated that every agreement which contains an unlawful consideration or object is void. Lastly, in the case of Tan Kok Siang versus Kemuning Setia, the appellant's promise to stay until the end of the project was not a term which was fundamental to or was at the root of the employment contract. This was a form of breach of contract.
So what is the connection in terms of similarity in my case?
In your case, let's break it up into few situations. Firstly, if Pulse enter a separate deal with BioCare while holding that understanding with you, they may have misrepresented their intention. Secondly, since the platform was funded by a public grant with a non-commercialization clause, any commercial use, including BioCares, could render that agreement void. Lastly, if Pulse has materially breached your agreement, promise exclusivity or joint control over the platform's use, allowing a third party, which is BioCare, to use it without your consent, you may able to terminate it and seek damages.
In conclusion, you might sue BioCare for the agreement made with Pulse in addition with the digital screening and partially funded by a public grant event. You can also make a whistleblower report to the health ministry, which might compel them to enforce the right law and protect public interest. It's clear there's a misuse of proprietary software since Pulse tried to have a business advantage by offering their service to BioCare.
We had the agreement solely through the exchange of emails. Despite how there's no signed documents, there exist implied conditions where Dr. Sarah Khalid should not engage with other similar programs for at least a year after her improvement. Plus, Arif Medical had also paid her monthly honorariums, and now she withdraws so suddenly, causing us a huge loss.
Mr. Arif, a contract doesn't necessarily need written documents to be legally binding. In Section 10 of Contract Act 1950, it doesn't exclude other forms of agreement such as oral agreement and informal documents. There must be a clear proposal by one party and an unambiguous acceptance by the other. However, that's not the main issue here.
What do you mean?
Main issue of the situation is that the non-compete clause, the ROT clause, was made with the intention to restrict Dr. Sara to join the other programs for at least a year after her leave. Of course, generally this would fall under Section 28 and therefore void, but under several exceptions, they can be enforced. What needs to be discussed here is whether the ROT clause falls under Exception 2 prior to dissolution of partnership, seen as to her involvement in a competing platform soon after she left, but Exception 2 and 3 only apply strictly for partnership. However, based on the fact you presented, Mr. Arif, Dr. Sara is a full-time public health doctor whom you engaged to conduct a series of teleconsultation. But this arrangement is not a partnership, nor does it have anything to do with shared ownership, control or profit sharing. She was simply involved in a consultation arrangement which you paid honorariums for. Therefore, she's not a partner.
Then I can pursue breach.
There may be other forms of breach, but you can't exactly enforce the ROT clause due to the Section 28. To illustrate, we'll take a look at the case of Nagadevan Lucky Maharindam versus Millennium Medicare Services.
What is this case about?
Okay, the appellant was a medical practitioner in a partnership agreement where it was agreed that he wasn't allowed to set up a new business establishment within a radius of 15 kilometers and within the period of 3 years, or work as a partner or employee after leaving without written consent of the managing partner. Later, he decided to resign and served a 3-month notice only to work under a different establishment before the expiry of the 3 months. However, the court held that based on the facts presented, the appellant was not a partner, rather a partner pursuant to agreement. Thus, it does not fall under Exception 2, which only applied in the agreement of the partnership. The appeal was allowed.
I understand, Ms. Nusra. I might fail when trying to take action against Dr. Sara Khalid since she is not a partner. The clause is ROT and can be enforced. It is like you said, it's void. Dr. Amir is a respected doctor in the MBGS partnership, but a few months ago, he sent a proposal to investors about opening a new clinic. And concerningly, the proposal features similar branding, layouts, and visuals that strongly resemble MBGS. But what action can I take against him if he has not breached anything yet?
Dr. Amir Iskandar has left Arif Plus or breached any of the clauses, his conduct is a signal to disengage improperly or breach of confidentiality. I believe this will cause your business a great harm if it were to happen.
Correct. So what can I do?
Dr. Amir is a partner and will have to look again at Exception 2 and 3 of Section 28. Exception 2 allowed ROT clause to be enforced prior to dissolution of partnership, while Exception 3 allowed it during continuance of partnership. Please bear in mind that there exists a general principle where ROT clause are only applied to post contracts, and thus it's not allowed during a contract as stated in the case of Polygram Sendirian Berhad versus the search where the plaintiff failed to prove the non-compete clause they made fell under any exceptions. That's why, Mr. Arif, you have to be very clear on the scope of your clause, because once it deemed to fall outside of exceptions, the geography, location, range or period is irrelevant even if they are somewhat reasonable. You have to review and update the already existing non-compete clause to include that no partners shall carry on their trades or arrangement that might hurt the partnership within the scope you specify. I noticed there's also a clause that prepared for the dissolution of and during the continuous where the partners are prohibited from setting up a new clinics within the 30 kilometers and within 5 years.
But I want to prevent any damages from happening to my business. He might still breach the clauses too.
What I can suggest is you must prepare for legal action if that becomes true in the future. Injunction to stop further harm and claims for damages and compensation. This has already been in the case of Polygram Sendirian Berhad versus Hilary Ang and Ors, where the plaintiff was granted injunction by court after their claim of breach of ROT clause succeeded. The court had also acknowledged the future harms it would bring to the plaintiff, a company where the defendant, a music band, had higher selling power than them. But in the meantime, you can send out warning notices and memo to the investors regarding Dr. Amir Iskandar and demand an explanation for him. Restrict any confidential information of the partnership to him or plan for his separation if necessary.
I understand. Thank you.